Parties have a consent judgment of divorce signed January 8th, 2019, which orders Mr. Short to contribute child support and medical support for one child in the amount of $363 per month. This is his first show cause hearing with the court, and it appears he lost employment in August of this year. The balance on the account currently owed is $2,480.15, of which $2,184.54 is owed in child support to Miss Rogers. $148.61 is owed to the state medical support, and then there are fees. Payments on the account for the past year came through income withholding. Recently, in December of 22, current plus arrearage is posted. January of 2023 through May of 2023, the same. $337.02 posted to the account each month during that time period. The last payment on the account was September of this year for $71.30.
Okay, thank you. Mr. Short, are you currently employed?
I am not currently employed.
Okay. When did you last have work?
I'm going to say October with Hayes Manufacturing for 2 weeks.
Okay. And why was it just for 2 weeks?
The job just wasn't working out for me.
And what was what were the issues with that job?
I wasn't cut out for the position.
And what was wrong with it for you personally?
The scheduling. I was kind of misled into what the actual job description was to be performed, and it was something that they said it was what it wasn't. So after spending 10 years with Mansalona Public Schools and dealing with that wrath, I decided I would no longer work for anyone who was going to treat me or mislead me in any direction.
And how did they mislead you?
The job description.
Right. And what did it turn out to be?
A glorified janitorial position.
And what were you looking for?
Technical. I was supposed to be working on CNC machines, not emptying mop buckets and taking the trash out.
I see. And what did you do when you were with Mansalona?
Facility operations.
Okay. And so are you looking for CNC type work now?
I actually have a job. I'm starting Monday. I've filled out 2 job applications every week for the past 3 months. So I'll be starting with Top Notch Heating and Cooling on Monday.
Okay. So what can you tell me a little bit about that job?
Heating and cooling?
Your position with Top Notch?
Yeah, service technician. I'm HVAC certified, so.
Okay. So did they promise you any kind of, specific amount of hours?
That will be full time. I haven't received the employment package yet. I'm assuming I'll get it today or tomorrow.
Okay.
I do know I will be starting on Monday if everything looks legit.
Okay. So as far as child support is concerned, do you have, any ability to make any kind of payment at this point?
Well, once I start my job. So allow me, if you would, just to give you kind of the breakdown of how I ended up in this position. In March, I lost my mother-in-law, so it brought a hardship with my wife and my father-in-law being in the UP, who's elder and has no one to take care of him. That was in March. May, I had to take time off, which allowed, I guess, kind of put me in the position to lose my employment with Mansalona Schools due to taking excessive time off, which they got me for insubordination, which wouldn't allow me to even collect unemployment. I had some savings built up to kind of get me through, which I've exhausted those. And then, kind of getting through this hardship, applying for jobs and doing a little bit of side work here and there, and taking care of what I've needed to take care of.
Okay.
And it's really in this position. So now, once I get back on my wheels, which I'm excited to go back to work Monday, hopefully this is going to be a good gig for me and start paying you guys back.
Well, it's not us. It's child support for your co-parent. So,
Okay. Well, on top of that, sorry to interrupt you.
Yep.
I had to pay out of pocket for orthodontics, which I had to cash in my 401k for, and that was $5,383 in July. I've also paid my ex's gas bill for 3.5 years. She switched that into her name, leaving me with a $538 bill to pick up. I've paid for everything. I've gotten my son groceries. I mean, I've done, what I've had to do to make sure he's taken care of in the meantime. So, I mean, I had that 401k and some other, some money put away to kind of let me by with friend of the court payments. And, I unfortunately had to exhaust that into bills.
for the orthodontia, that's supposed to be split up by a certain percentage. Did you follow that?
Well, I didn't get any of that, and everything was in my name. So if I didn't pay it, it was going to affect my credit.
Okay.
She
So,
did say she was going to.
you can get you can get reimbursed for that. Are you trying to do that?
I would like to. I mean.
Okay. Well, you should, the front of the court can help you do that. So you should go online to the front of the court website, and they've got instructions for how to get reimbursed from your co-parent on that.
Okay.
You should do that.
Yeah, I have the receipts.
Okay. Keep all the receipts, and it's got detailed instructions. Follow those instructions, and the wheels will get set in motion for you to get paid back whatever percentage your co-parent is responsible for on that out-of-pocket healthcare cost.
Right. Okay. Well, that's good news.
All right. I hope your job works out. Let's get an order of income withholding out to Top Notch. And for good cause showing, the order to show cause is dismissed. That will conclude our hearing. Thank you.
Thank you.
All right. Yep. Thank you.
094DM. Parties in the case have a fifth order modifying judgment of divorce signed July 25th, 2023, which orders Mr. Steele to contribute child support, health insurance premiums, and medical support for 2 children in the amount of $648 per month. That charge began August of this year, which was an increase from a prior charge of $189 a month. There's been prior enforcement on the case, and Mr. Steele also did respond to an ability to pay worksheet, which is available for the court's review if desired. Current balance on the account owed is $3,995.26, of which $3,890.26 is owed to Ms. Uhas in child support and medical support, and then there are fees. In the past year, we had payments on the account through income withholding. Current plus arrearages were paid from December of 2022 through March of this year. No payment for April, but then current plus arrearages paid again May through September, and that was the last payment on the account that posted in September.
Okay, thank you. Okay, so Mr. Steele, are you currently employed?
No, I am not.
Okay. When did you last have work?
If I'm correct, it was September 19th.
And what did you do for work at that time?
I was working for Spectrum Communication, Charter Communication.
And what did you do for Charter?
I was a technician installing and troubleshooting cable.
Okay. And how long had you been with Charter for?
Since April.
And prior to that, were you without work for a period of time?
Just for a short period, about a month. That was just due to waiting for a background check and drug urinalysis and all that to come back.
Okay, so then, prior to that month, what did you do for work?
I worked for the Grand Traverse Band as a housing maintenance.
And how long were you with the Grand Traverse Band for?
Since November of the prior year.
What happened with the Grand Traverse Band job?
I got let go due to attendance. Right around Christmas time, both my vehicles went down, and I was unable to get them up and running in the time, so they extended my probationary period. And then I got sick one day and didn't realize that part of my extension was if I missed one day, they'd let me go.
And then what happened with the charter job?
Charter, I was forced to quit due to my knees. I got to have double knee replacement. I'm waiting to hear from the surgeon right now about a sooner appointment than the beginning of January. Basically, it was either I quit or I had a 100% inclination they were going to fire me because my performance was not where they wanted it.
Okay, thank you. And Mr. Steele, we're going to send you a physician's disability form. You're going to need to send that to your healthcare provider. They're going to fill it out and return it to the front of the court. So I'm ordering you to facilitate that. You'll be getting those forms. And then when we return on this hearing, we're going to find out, what the forms say, and we'll go from there with your what you're saying with your healthcare issues. At this point, due to what's been indicated, I have to adjourn this hearing. We will return for a continuation show cause hearing within the next month or so. And Mr. Steele, you will have been expected to have provided those forms to your physician. At the continuation hearing, Ms. Uhas, I will be asking you to weigh in on how the lack of support has affected your household. Otherwise, court is in recess at this time.
This is an arrears only
Okay, thank
case,
you.
and we were last in court in July of this year. The hearing dismissed. Mr. Taton has made offers to pay $50 a month on the account until paid in full. Last charge was $230 per month, and there were 2 children between the parties. The remaining balance owed on the account is $4,302.83. Medical support owed to the state. There is a small balance owed to a former third-party custodian, $18.84 to Barbara Lacey. Miss Bolin is owed $1,988.75 in support arrearages, and then there are fees and costs. And the payments in the past year, in July of this year, Mr. Taton had made a $150 payment to catch up for a couple months of missed monthly payments. And then October, we received involuntary intercept of $16.
Okay, thank you. All right. So Mr. Tattinen, are you having any health issues?
Not at this time, no.
Okay. And what is your housing situation?
I stay here and there. I use my mom's address for all my mail and stuff.
Is your mom's place one of the places you stay at?
Periodically, yeah.
Okay. And is this your mom's house that you're at right now?
No, I'm at the lady's place that I was doing the in-home health care for, but since she got in trouble and she's been incarcerated, I ain't been able to collect my home health care. I'm still trying to keep the place up and running for her and not lose everything.
And as far as this house that you're at right now, so it's the house of a woman for whom you're doing home health care?
Yes, it was, but I don't know if she's gonna be back anytime soon.
Where is she now?
Well, she's in Antrim County Jail right now, going to court herself in Antrim. Then they got to take her back up to Emmett. I don't know what's really going on up there. So as long as she is incarcerated, I can't claim the home health care because the state's already doing it. You know, she goes to the hospital overnight. I can't claim that day.
I
You know,
see. So you what's the claim process? How do you claim it?
On Champs, you know, through DHS.
Oh, is that a DHS program?
Yes.
Okay. Okay. And then what do you do for transportation?
I asked the neighbors for rides, you know, since she ain't been around because I don't have a license.
Okay. And I saw somebody else in the house with you this morning. Is that somebody that can help you when you need rides and stuff?
Yes.
Okay.
Well, that's why he is here. My son's here too.
Okay. Okay. And how old is your son?
19.
Okay. Is he employed?
Yes.
Okay. What does he do for work?
He works at the Easy Mart there in Bel Air.
Okay. Have you considered maybe finding a job at Easy Mart? You could just kind of write in with your son on that.
I started working with another guy Monday. I got 5 hours, and you know, when he does tear offs on a roof, doing the ground cleanup. You know, yesterday I spent most of the day trying to snow blow trail to even get to the main road where I could go to town to try to get shoveling jobs.
Yep. Okay. And so
You know, so I can most likely make a payment this Friday from the hours I worked Monday.
okay.
But being snowed in yesterday, I couldn't go nowhere.
I see. Do you own a shovel?
Yeah,
Okay. All right.
like 3 or 4 of them, and a snowblower.
All right. Well, it's we're going to get a lot more snow than we have now. I mean, it's right now we've only got a few inches. I was out there shoveling myself the other morning. But anyway, okay. Was there anything else you wanted to say today?
No.
Okay. So
I know I owe the debt, and I'm trying to pay it off. I've been paying friend of the court for 32 years, and this is the last one I got to get paid off, and then I'm done.
All right. Well, the sooner the better. But today I do have to apply MCL 552.633. That statute provides at subsection 3 that in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer has currently available resources equal to 1 month of payments under the support order. This is an arrears only case. And Mr. Taton previously offered to pay $50 a month. That hasn't been happening. So I guess at this point, the question is, does he have the capability or capacity to be paying at least $50 a month? He has housing. There's the woman who's in Antrim County Jail. He's been doing home health care for. It's a DHS program. He has been receiving payment for that. His son is 19 years old. I'm going to go ahead and make my findings now. His son is 19. He's employed at the local Easy Mart. No indication that Mr. Taton can't rely on his son for transportation. He also indicated he asked his neighbors for rides. He's certainly capable of shoveling himself out. He's indicated he doesn't have any health issues. He can get down to the road. He can get rides. He can find other work. He hasn't really made much of an effort to do that. On this record, the court finds that the payer has not rebutted the presumption that he has the capacity to pay at least $50 a month. Therefore, Mr. Taton, the court finds you in contempt of court. You'll be placed on probation for a period of 2 years. During that 2-year period, you'll have to pay $50 a month. That's your payment plan. If you do not make payments according to that plan, a bench warrant will be issued for your arrest. The amount of the bond will be set at $500, which you'll have to pay or serve 5 days in jail. That'll conclude our hearing.
06491DS. This is a hearing adjourned last from October 25th to today's date and time. And Ms. Hilderbrand at a prior enforcement hearing had indicated she had given birth to a baby in approximately May of this year, and that the minor child had spent some time in the NICU, which prevented her from working. It was requested she provide some medical information about her ability to return to work or an ability to pay. We did not receive that information, but she has had prior enforcement. No payment plans or enforcement of any kind of warrants have resulted. This is, parties in the case have a third order modifying order for custody, support, and parenting time signed December 15th, 2020, which currently orders her to contribute child support and medical support for 2 children in the amount of $316 per month. The balance on the account currently owed is $2,373.50, of which $2,244 is owed to Mr. Smith in child support, and then there are fees. The payments on the account in the past year, in January, she made a $100 payment. In February, she paid $600. In March, $2,648.54 was released to the account from an involuntary offset. And then in September, she did make a court-ordered lump sum payment of $600.
Okay. Could you pull up the order from the last hearing, the adjourned order?
Yes.
All right. So Ms. Hilderbrand, do you have any documentation at all, regarding the medical issues that you might be experiencing or anything like that?
I have paperwork from my doctor of what I'm being treated for, anxiety and the depression disorder. I had a lot of issues with like postpartum depression. I do have that paperwork from my doctor.
Okay.
And I was put on medication for my anxiety, and I had some problems with my blood pressure. I was put on some medicine for that also. And I was also diagnosed with diabetes from
we need the paperwork. You were ordered at the last hearing, and if you haven't done that yet, so you do need to actually hand in the paperwork so we can look at it.
Okay.
So we need to do that. So otherwise I'm just going to adjourn this again for you to provide paperwork regarding any health issues that you're having. And then also we're going to send you a physician's disability form that you'll provide to your healthcare provider to be filled out and returned.
Okay.
We need some sort of paperwork to support what you're saying.
Okay.
Okay, so we're going to adjourn to do that. Thank you.
Okay.
DM,
All right. Thank you.
Thank you.
Amy Hudson versus Paul Burt. This is the date and time set for a friend of the court show cause hearing for denial of parenting time. Appearing at today's hearing via Zoom, there being no objections, is the plaintiff, Amy Hudson, and her attorney, Elena Lentz, and the defendant, Paul Burt, with his attorney, Amy Swager. This is a case where there was a order to show cause issued dated September 8th, 2023, alleging that plaintiff had failed to return the party's minor child on or about August 27th. To the court's understanding that the minor child is still not going to defendant for parenting time pursuant to the applicable court order. Ms. Swager, you may proceed.
Thank you, Your Honor. Amy Swager on behalf of defendant Paul Burt. Your Honor, my client filed his appropriate show cause, a request for show cause hearing. His last parenting time was August 27th, 2023. The plaintiff is withholding a 16-and-a-half-year-old Kai. It doesn't make any sense. The parties, my client and Kai, have engaged in therapeutic counseling. The counselor discharged them yesterday. My client, pursuant to the valid court order, is granted primary custody of Kai. So he's missed every week of parenting time with Kai since he failed to return on August 27th. So it's harmful. Plaintiff is behaving contrary to the terms of the valid court order. The therapist has released and discharged them. There's no mental health issues. There's no CPS issues. There's no danger issues. There was never any concern for the prolonged withholding of parenting time with my client. So this time, we're approaching the holidays. It's abhorrent that my client now has to worry about whether or not she's got the capacity and disposition to provide the child for holiday parenting time. So I wonder about her ability to appropriately marshal parenting of a 16-and-a-half-year-old young man. I'm also mindful, Your Honor, that plaintiff has filed a motion to modify parenting time. She's requested in her initial pleading 50-50 custody. Plaintiff then retained counsel and is requesting primary custody. That hearing is scheduled for January 3rd and 4th.
Thank you. Ms. Lentz, is that correct? There's a pending motion to modify parenting time?
Correct, Your Honor.
All right, so the court's had an opportunity to review MCL 552.645 sub 3. That statute indicates that within 21 days after the date of the notice under section 4.4, a parent who is notified of a contempt hearing under section 4.4 may request a hearing on a proposed modification of parenting time. As noted, this is a case where the show cause order was issued on September 8th. The court takes notice that an amended motion to modify parenting time was then filed by the parent who's been required to show cause, Miss Hudson. She filed her amended motion on September 14th. So that's certainly within the 21 days after the date of the notice for the show cause. The statute continues that the court shall combine the hearing prescribed by this subsection with the hearing on the order to show cause, unless the court finds for good cause shown on the record that the hearings should be held separately. If the court finds that the hearings should be held separately, the hearing on a proposed modification of parenting time shall be held before the contempt hearing. So I guess, Ms. Lentz, your client's been required to show cause. There's a pending request to modify parenting time filed by your party, your client. So the statute directs this court to essentially adjourn this show cause hearing to have the hearing on a request to modify parenting time held first. So what's your position on all that?
Our position, Your Honor, for judicial economy would be to have everything heard or combined onto the January 3rd and 4th date that's previously set. Maybe I'm wrong. I don't know if it's possible to have a hearing date sooner than that January 3rd and 4th, just with the court's docket, which is set for a 2-day hearing. So I don't know if having it before this contempt hearing is even feasible. But we would request that the contempt hearing not occur today pursuant to MCL 552.6453 and either be combined with the January 4th and 3rd date and or that date be rescheduled or that date be canceled, schedule it before the contempt hearing, if that makes sense.
Ms. Swager, as her counsel is aware, the word shall is mandatory. This court does not have authority at this point to conduct this show cause hearing because a motion to modify parenting time was filed within 21 days after the date of the notice for the show cause. Because of that, this court has no choice under the statute but to adjourn this hearing and consolidate it with the pending parenting time hearing, which is currently set for January 2nd and 3rd. That's what today's order will reflect. The show cause will be consolidated to be heard before Referee Hagan beginning January 2nd. But I caution Ms. Lentz, your client, that if counseling has in fact ended and if apparently successfully because there's been a discharge as represented by Ms. Swager, under that set of facts, it's this court's opinion, not an order, that parenting time should be effective and it should be taking place right now.
I understand, Your Honor. If I could clarify briefly, I think the word discharged is a bit misleading. The counseling sessions ended because Kai lost coverage under MI Child, whatever that health insurance is. So they were forced to change counselors. This isn't a congrats, you guys are all good. You don't need any more treatment. But I do take note of Your Honor's directive and will speak to my client in such regard. But I do think discharged is misleading as it was not a congratulations, you successfully completed treatment.
All right. And then, I don't just mean to weigh in on your client, Ms. Lentz. Ms. Swager, obviously this case is not before me, but from my perspective, reading the amended motion, the alleged message from Mr. Burt to the child on September 1st regarding essentially minimizing the child's previous indications of thoughts of self-harm was extremely disturbing to this court. Obviously, this case is not before me today, nor will it be on January 2nd, but I would caution your client, Ms. Swager, to take the counseling seriously and to take seriously the child's indications of thoughts of self-harm. Otherwise, this court is going to adjourn and consolidate for the reasons stated, and that will conclude our hearing.
Thank you, Your Honor.
Thank you.
Thank you.